The event today, as the event that we're sitting at here, brings together a group of specialists and experts in the area of various areas relating to investment and the role of the financial sector, specifically looking at state-owned financial institutions. Some of the questions we would like relate to where within the guiding principle framework do state-owned financial institutions rest? Are they subject to Pillar 1, Pillar 2, or a combination of both? We would also like to examine questions around the issue of transparency, the notion that a state-owned entity may be subject to principles of a state's obligation to be transparent, but also simultaneously are subject to a financial institution's imperative to respect client confidentiality. When looking at issues of remedies, perhaps this panel could explore balancing the risk of or the need of enforcing compliance with human rights standards by large-scale infrastructural projects or the clients of the financial institutions, while at the same time not irresponsibly withdrawing from projects, leaving perhaps issues in a worse situation. And finally, one of the questions that repeatedly has come up over the past 2 days, which is, are there obligations on the part of state-owned financial institutions in respect of activities extraterritorially? And if they are subject to state imperatives as a state entity, under Pillar 1 or 2 or 3, or all three, what then is its obligation beyond its borders? My name is Bonnie Meyersfeld. I am the Director of the Center for Applied Legal Studies in South Africa, and I will be chairing this panel, moderating this panel, and I would like to hand over to our first panelist, who is from the Brazilian Development Bank, Jaime Gorstejn. Have I got that vaguely correct?
Yes.
Yeah, not too bad, not too bad. And I am going to ask the panelists to speak for a maximum of 7 minutes.
Thank you. Well, thank you very much for the opportunity to be here today and share with you our views and our policies and the dimension of human rights and social development, how it works within the Brazilian Development Bank. So by way of a brief introduction, BNDES, the Brazilian Development Bank, is owned by the Brazilian government, but it's not a government department. It's set up as a bank subject to banking regulations and banking supervision. But as our sole shareholder is the government, we are policy driven. So we have our mandate to promote development in all of its dimensions. So it's not just economic development, it's also social development and environmental development. And this is very clear in our policies. So the integrated approach to development. And that encompasses industrial projects, infrastructure, export financing, small and medium companies, innovation, so the whole range of projects and clients so that we can fulfill this mandate. And so this is very clear in a document that we have, the social and environmental responsibility policy, integrated approach. The second is respect for human rights. The third is transparency. And the fourth is proactivity. So let me just walk you through briefly these aspects of our social and environmental responsibility policy. So I mentioned the integrated approach. Proactivity. So we have in place very strong due diligence procedures to try and detect any possible impacts that our projects would have in terms of the environment, in terms of the communities where the project is being developed. And so we try to detect this in the early stage and try to mitigate this risk. And I'll tell you briefly how we do that. We also do due diligence on the project sponsors. So maybe the project is a low-risk project, but the sponsors may have been involved in any other project, not necessarily, not financed by BNDES, and because of that, they may be in certain government blacklist, so to speak. So in terms of labor kind of work that is similar to slave work, so to speak, I mean, in very, very bad conditions, or disrespect for the environment. So the government has, the different government agencies, they have a kind of a blacklist of project sponsors involved in this kind of activities, and BNDES is prevented from dealing with them, even though the current project is a low-risk one. So BNDES is inserted within the wider government policies of social and environmental development. In terms of proactivities, we have, in projects where we detect in our due diligence process any possible impact on the environment or in the communities where the project is being developed, we have certain financial instruments aimed at mitigating this impact. So we try to encourage the project sponsors to undertake social projects that would help and mitigate any possible risks to the communities. For example, we recently financed a project by a poultry company in a small town in Brazil, and we detected that that project that they would bring perhaps will increase the population of that small town, and the social system in terms of education and health potentially would have problems coping with this increase in population. So we provided a special line of credit to the project sponsors so that they could build a new school and a new hospital. So that was part of it wasn't in the original project, but within our project structuring process, we encouraged and we managed to have the sponsors building these new facilities for the community. Another pillar of our policies is transparency, and so we believe that we have a very strong policies towards transparency. We have in our website we show what are the projects we're working on, what are the characteristics of the projects, project sponsors, and the various sectors that we work on. And of course, this is a subject also to certain business imperatives. So we deal with commercially sensitive information, of course, as any bank, and potentially the disclosure of commercially sensitive information could damage the client and the market in general. So there's a balance of transparency, accountability, and commercially sensitive information. So we try to do the best to have the maximum transparency possible. The next point I would like to present in my initial remarks is that recently BNDES is promoting a forum to engage with non-governmental organizations in Brazil, with the civil society, to see how BNDES can address concerns, mostly in the sectors such as energy, urban development, and also the international business of BNDES. So increasingly, BNDES is also supporting Brazilian companies outside Brazil, and although this is very new, we are engaged in a discussion with society on how we can also promote the same policies we have in Brazil in projects overseas. Of course, it's a very different way of working, and BNDES organization that's very different from multilateral banks. So our mandate is very different. So these are my initial remarks, and I'll save some other thoughts for the Q&A session. Thank you.
A hearty thank you, and a hearty thank you for keeping well within the time. Our next speaker is, this is going to be a challenge to see if I can pronounce it correctly, Kamil Zabielski from Norway, from specifically the Norway Export Credit Agency. Thank you very much. You have the floor.
Thank you. My name is Kamil Zabielski, and I am responsible for human rights due diligence at the Norwegian Export Credit Agency, which is an agency under the Ministry of Trade in Norway. Since my time is limited, I'm going to address three specific questions. The first is, what are export credit agencies? The second, what human rights due diligence procedures are applied by these agencies? And thirdly, what are we doing in Norway, and what are some of the challenges that we face? So for those of you that are not familiar with export credit agencies, or ECAs as they're commonly known, these are basically public agencies that provide government-backed guarantees or insurance to companies within their country in order to promote export, very simply. To give you an example, say you have a Norwegian company that is producing a turbine. That turbine is going to be exported abroad to a hydro project. The Norwegian exporter will loan money from a bank in order to produce that turbine. And the ECA will then in turn provide a guarantee to that exporter. And this guarantee will be against the loan in order to cover such risks as commercial risk, so if the buyer doesn't want to or cannot pay for the equipment, or second, for political risk, so if there is expropriation or military coup in the country, then the exporter or the buyer, they're not stuck with the loan. It's backed by the guarantee institution. And each of the 34 countries of the OECD have such an export credit agency. So what are the human rights procedures that are being applied by these agencies? Well, for export credit agencies outside of the OECD, there's no specific agreement on how human rights issues need to be considered. And therefore, the extent to which these export credit agencies look at human rights is very much dependent on their internal policies and their government positions. However, for export credit agencies within the OECD, there is a very specific agreement called the OECD Common Approaches on Social and Environmental Due Diligence. Now, this is an agreement that was revised in 2012. During this revision, there was incorporation of social risks and social impacts throughout the entire agreement, but also explicit reference to the UN Guiding Principles. In practice, however, what this means for export credit agencies is that they address human rights by benchmarking projects against international standards. So the IFC performance standards, some of you are familiar with these, and the World Bank safeguard policies. So you can say the robustness of the human rights due diligence procedures are only as robust as these ECAs are applying these international standards. The agreement also outlines that the members are to build a body of experience on how to conduct this due diligence, and this is a work in progress. But it should be mentioned that there's a handful of agencies out there which have made a commitment to the UNGPs, which brings me to my third question: what is Norway doing? First of all, we have a human rights policy and a commitment to operationalize the UNGPs in all of our transactions. In practice, this entails that we need to expand the scope of the transactions that we are looking at to go beyond what is required by the OECD. Now, this means we also have to look at such things as mobile assets. Projects that do not have a fixed location, like a ship, are not covered under the OECD agreement. Transactions under 2 years are not covered by the OECD agreement. And transactions which are under the equivalent of 10 million euros are also not covered. So by making commitment to UNGPs, we also have to look at these kind of transactions. In order to implement this policy, we have a specific 5-step due diligence procedure. I will only very briefly go through it right now. The first is that we identify human rights risks in all of our transactions. So we have sector-specific human rights questionnaires, we conduct online research, and we look at the human rights context of the projects. Step 2 is that we assess the human rights impacts. How do we do this? We require environmental and social impact studies. We conduct site visits and country visits. We use third parties to evaluate labor rights. And most importantly, we do robust benchmarking against international standards, the IFC standards, and internationally recognized human rights. After we've assessed the impacts, we need to take actions to mitigate or prevent. So how do we do that? We actually require our clients to have management systems and plans in place, including grievance mechanisms. And we make these legally binding as conditionalities for our support. Step 4 is that we account for how these requirements are implemented. How do we do that? We have legally binding monitoring reports that need to be delivered to us, or requirements that they have to follow certain improvement plans. And finally, we disclose. So all the projects that we have supported, information on those projects are found on our website. And particularly medium and high-risk projects, you will find the impact assessment information on our website at least 30 days prior to our support. 30 days. This approach does not come without its challenges, and I don't want to give you the impression that this is very easy, because it's not. I would say our main challenge is this issue of leverage, which we have talked very much about. By the nature of our business relationship, we are not causing or contributing the impacts. We are linked to them. This does not mean we don't have responsibility to conduct due diligence. It just means that because we have limited leverage, we may not be in a position to actually influence the impacts. Now, let me give you an example of this. Take a typical example where we are providing a guarantee of a loan. That the bank is providing a loan to an exporter. That exporter is delivering a product to a larger project. They're one of many exporters in this project. The impacts are being caused by the project developer, or perhaps a third party, a contractor, which is building a pipeline or a transmission line or access road. So what is reasonable for us to expect from the exporter? And what is reasonable to expect from us as an export credit agency? These are very challenging questions. As a state-backed export credit agency, we do not share the view of some that because you don't have leverage, you don't do due diligence. That's a very important point. And to conclude, I just want to say we have the view that, first of all, if you have leverage, which we often do, and perhaps often have more leverage than we perceive that we have, then we need to take action. If we do not have leverage, then we must exhaust all avenues to gain that leverage. We can talk to banks, we can talk to the project developer, we can talk to other export credit agencies. We can gain leverage. If that's not possible, as a minimum, we need to at least prioritize the most serious impacts and take action. If not, then we need to consider not supporting this project. So I'll just leave it at that, and I'll take any questions afterwards. Thank you.
Thank you so much. And again, so sorry to keep you short. And I very much hope that the question of leverage and those really practical constraints will come out more in the discussion, so we can have a robust contribution around that. Our third panelist is Juana Kweitel from Conectas in Brazil, and I'll hand over to Juana.
Gracias. Voy a hablar en español.
I'm going to speak in Spanish. There will be interpretation. Good afternoon. On behalf of Conectas, I would like to welcome the decision to include the discussion on state institutions, and I would also like to thank the panelists from whom I've learned a lot. I will basically spend my discussion on the fourth principle, as well as speaking about the BNDES. In light of this, I would like to discuss different areas on which we can then carry on the discussion. We have transparency, respecting indigenous peoples, ensuring democracy, as well as reparation mechanisms. These issues have come out of a survey that was carried out throughout this year, and from this we interviewed different banking clients, banking officials, as well as NGOs and other institutions working on this issue. There are a number of institutions who were included in this dialogue between the civil society and the bank, which Jaime was part of. And it is hoped that in 2014 there will be different changes made to the policies as well as the practices implemented by the BNDES. First of all, to speak about which pillar we should consider financial institutions. Are they companies or are they state institutions? Some people believe that they should be considered under the first pillar, and it is states that need to implement different regulations to ensure that they can fight against human rights violations. And also, in line with Principle 4, as the closer the state is to being a company, then the more they need to respect human rights. There are negative consequences that can come from states. States have to ensure that their own institutions do respect human rights, as well as the companies that support them. One of the central issues that was previously mentioned was transparency. For the BNDES, after a strong campaign launched by civil society in 2007, a new project was launched which took into account the values of the beneficiaries, and this was very important. However, it is not enough in terms of the policy of transparency. The BNDES must follow other institutions, financial institutions, whether international or not, in line with their own projects. They have to do this for their own analyses and monitoring. This would include the law on access to information from 2011, and also being able to access federal courts. A decision was made to say that the analyses of all projects have to be made public. All those projects that were launched between 2011 and 2013. The documents and analyses that are taken out, that are carried out by departments, are very important. These documents are essential so that we can carry on discussing them, and they are of the public interest because most of the resources used here are indeed public. To finish this issue on transparency, I would like to raise a recurrent issue, and that is banking secrecy. There are three arguments which counter the argument for keeping banking secrecy, which can be seen in the analyses carried out. First of all, public interest must be more important than banking secrecy. Secondly, secrecy can lead to a company being left in a negative position. There should be no protection on technical reports made by the bank in itself. And thirdly, the application of the law on access to information stipulates clearly that there can be no secrecy which will be harmful to fundamental rights, as well as ensuring that this is the case for the public financial institutions. In light of these considerations, it is necessary that we need to review our practices and transparency policies so as to better ensure that we are following our project. Secondly, the development banks need to take into consideration what projects they are implementing in vulnerable parts of society, especially for indigenous populations. In Brazil, these populations are protected, but we need to ask ourselves, how will the bank act if the specialized institutions do not protect these peoples? Should the bank ensure that it has these policies in place to protect these rights of indigenous peoples? The indigenous peoples' lands are also being affected by different projects, whether these are hydroelectric projects or others. This has happened for Belo Monte in Brazil, and the Development Bank does need to question its own practices on this matter. For both the national and international products, the Development Bank needs to ensure that when it does support a project, this has been done with free consent. This is the proposal that has been put forward by the working group of the guiding principles. And the last report of the working group, it was stipulated that those companies which are supported by the state or public institutions need to ensure that these have additional measures being applied to them by these states. In other words, for the BNDES or other institutions like this, we need to have additional measures. We can't just have the respect for national legislation. We need to have additional mechanisms. We also need participative mechanisms to ensure that there is a free and informed consent respected, because this will also ensure that there will be better responsibility and accountability. And finally, I will leave the fourth point for the discussion. But I just want to mention the activities of national banks or multilateral banks in authoritarian regimes. There have been recent cases, as I just mentioned, and in principle for third players, it is very difficult to understand what the financial architecture is. Normally, banks only do support banks for exporting goods and services. For example, building a hydroelectric plant in Peru, ports in Cuba, or agricultural installations in Zimbabwe. We will also be opening institutions in Johannesburg and London. With regards to international projects, we need to have a space where we can have the participation of either Brazilian civil society or civil society in the country where the projects will be carried out. This mechanism has not been developed. For these kinds of projects, in order for local legislation to be respected, a legislative framework needs to exist. On the one hand, if we only respect local laws, then perhaps we will be respecting laws that are inferior to Brazilian legislation. This is a very fragile mechanism because we do not know all the specificities, and we do not know who is involved in this method. The international activities of a bank can also be seen in the multilateral framework. So we need to ask, what can they do in their institutional framework to ensure that they are working correctly internationally? Especially in authoritarian regimes, the BNDES needs to ensure that there are networks created so as to ensure they are not guaranteeing violations in different countries where they act. And I will end now and speak in the discussion later. Thank you.
Thank you, and so sorry to rush you. I'll hand over to the commentators now, who I am sure have some ideas that they would like to impart. But for the sake of additional thought, if there could be some comments relating to the question that came out initially around leverage and possibly some of the challenges that state-owned financial institutions have in identifying and being able to address human rights violations that occur in their investment activities. And finally, if there can be some responses to the issue around transparency versus client confidentiality, and are these two irreconcilable competing interests? I'll hand over to our first commentator, Eleni Kyrou. Forgive me if I'm mispronouncing the name, which I'm sure I am, from the European Investment Bank, and you will have 5 minutes plus a little extra if you want to engage with some of the other issues. Thank you.
Okay, thank you, Bonnie. It will be a challenge to sum up the nearly 3-year process that the EIB underwent to integrate human rights in our work in 5 minutes, but I think I'll just stay with the key themes, and then we can discuss it in the subsequent time. Just for everybody's knowledge, in case you're lost, to understand where I'm coming from and what I'll be saying, comes from European Investment Bank, so part of the EU architecture, the European Union's essentially investment arm. Back in 2011, we got the mandate, if you wish, directly from Brussels, from the European Parliament, that we need to integrate human rights in our work. So a similarity with my colleague from BNDES, we're policy-driven. We don't develop our own policy ourselves. Being part of the EU architecture, several of the issues that we discussed today were straightforward in the sense that it wasn't a choice that we made, whether to integrate human rights or not in our due diligence. It was made for us. We didn't have to scratch our heads and think which is going to be the primary instrument of reference for us for human rights. As part of the EU architecture, we immediately had to refer to the EU Charter for Fundamental Rights, because this is the official human rights instruments of the of the Union. That charter became a legally binding component of the Lisbon Treaty, which kindly to us and all EU bodies made specific reference on extraterritorial jurisdiction. And what he was saying is that human rights, the charter, is also applicable to the Union's activities outside the 27, at the time now 28 member states. So a lot of the key fundamental soul-searching processes for us were fairly straightforward. We knew our instrument of reference. It was clear that it guided all our financing instruments, so we couldn't pick and choose. So in name, all our regions that we finance both within the EU as well as outside the EU. We finance both public sector as well as private sector. Of course, all these things did not come with challenges, and I expect that my colleagues, as well as other DFIs and MFIs out there, face these challenges, and there are lots of stories to be told on which is the most easily to persuade client, whether it's the private sector or the private sector. I think there's a lot to be said on that. In terms of remedies and balancing a compliant performance versus us pulling out, this is something that has been very much with us, even since before this undertaking started. And the minute the human rights, the whole agenda of human rights landed on our desks, we were confronted with a choice of perfection from the outset, or guaranteed perfection, or progressive realization, if I may say so, or progressive improvement or incremental improvement. What do I mean? Essentially, the dilemma we were faced in is, do we only finance projects that are perfect from a human rights perspective? Or do we use the leverage that we bring to actually lend added value to those interventions and help push human rights performance, compliant performance in any given project up a notch, or up 2 or 3 notches? I think for us that was a fundamental question, because it really guided how we're going to position ourselves, and it gave a lot of answers. It gave an answer to colleagues of ours who were concerned that, you know, our business model is just going to collapse, and, you know, what are we going? The world is not a human rights perfect place, if you wish. We decided that this is going to be our approach. We're going to lend added value the way we can, as much as the context affords us. In that sense, pushing the boundaries and leaving behind valuable precedents of what is possible in this field. So that in any given field, let's say, even in a country where the freedom of association, the convention has not been ratified, that we will go in and we will expect from our clients at a project level, because we work our footprint is very project. It's not at country programming or budget support, that at that country, at that project scale, we're going to create a positive precedent that respects the right to collective bargaining and freedom of association and promotes that. So if you wish, we create little bubbles. That's the vision, to create little bubbles of human rights compliance and improvement. And as for the UNGPs, because it's very important, the UNGPs for us, we took them into account since the very outset of our gap analysis. And what they constituted for us was three things. First of all, inspiration. Inspiration on nuancing the procedures of how we're going to apply the provisions of the Charter in our due diligence. The second thing was a wonderful driver, because we could turn around and tell both our shareholders, which is member states, as well as our clients, that the world out there is moving, both at the state level and at the level of businesses. So we can't, as a public bank, stay behind. I think I'll leave it for here because Bonnie is looking at me only with one eye, and we can take up.
And one is, and I'm not picking on you, Jaime, and I'm not picking on your anecdote, but what we know from the UNGPs is that the state's duty to protect doesn't disappear in any context. It doesn't disappear if the state contracts out for a private company to build a hospital or a private company to build a school. And the responsibility to respect, in a sense, limits the business responsibility. We're not about fulfilling rights. And so your anecdote about mitigating a very important human rights risk, and that is the inflow of a new population for an investment. And that mitigation also falls under the UNGPs. So what do the UNGPs mean also in how we prevent and mitigate the risks that are identified in due diligence? So if we remember, due diligence is not just a transactional due diligence where you're looking for risks, but it also, the UNGPs apply then through the prevention mitigation. So my question is, it's wonderful to look at new population growth and how you're going to handle that, but how should we engage the state then in ensuring the quality and sustainability of managing that risk, and what should be the company role? And I think it is actually something that now public financial institutions are going to have to think about. Is it just that you deal with the private sector and that they build the school and the hospital? Or actually, do they stay in there? We have to remember the state duty to protect, and what does it mean about engagement with the host state? So that was a question that came out of the anecdote. The second one was, what is the application of the UNGPs to different product lines and services that state financial institutions, but we can also include private financial institutions, are offering? So we heard export credit agencies, we heard Kamil mention certain product lines that are not caught by the OECD common approaches. We hear in different financial institutions there will be a number of products and services. What do the UNGPs imply for trade facilitation versus big projects versus small projects, where we know that from the UNGPs we have to look at impacts? Is it right to be looking at the dollar number of a project, or do we have to be thinking of impact? So we have now this tension where the world before us, we looked at the IFC over 2 years, 10 million euros, not covering mobile assets. Now we're in the world of the UNGPs where it forces us to look at impacts. So I just wonder, how are we going to do this? Thinking about the dimension, but also the different products and services. And then the real question in my mind from Kamil's talk was, it sounds wonderful hearing Norway, but we know that the world is not Norway. We know that a lot of financial institutions, when they talk about leverage, they actually confuse leverage with responsibility. Kamil would never do that, but there is that, we hear that conversation over and over again, confusing leverage with responsibility. It's a big problem. But what do we do about outside the OECD, and what do we do about other financial institutions even in the OECD where they use the same words but they may mean different things? So I think it's a big challenge for us. And then lastly, and I'm throwing another can of worms into the room, it is wonderful to say we use the IFC performance standards, we hold our projects to it, we want our project sponsors and those we support to be using IFC. But IFC performance standards are those standards that the project sponsor carries into the host state. what about the state duty to protect? What does that mean for the regulatory agencies that may not even know what the IFC performance standards are? What does it mean for their regulatory ability and their, quite frankly, their self-confidence in regulating those projects when they know that the lenders are counting on IFC performance standards? What happens with those young environmental regulators that say, oh, I guess I can't use my law because it's IFC performance standards? And so just a question that I wanted to have some reaction from. Thank you.
Thank you very much, and you've saved us about 8 seconds, so well done. Okay. I am going to open up to the floor, and we really have a great deal of time to engage in some of these issues. I will take maybe 3 questions at a time and then have some answers, or 5 questions at a time, but there does have to be equal representation, please, from various stakeholders. So as I understand it, we have civil society over here, we have states over there, and I assume then that that table is business. Okay, I think it's okay if you just say where you're from, and I'll make a note to then not ask your organization again. May I just, before handing over to the first question, ask if anybody would like to input around the question of the bricks and the new development bank there. So we have one. Which are you from, state? So you're from business, state? Civil society? All right, we'll take one from state and civil society, and then we'll continue to take more questions. If you could introduce yourself, please, yes.
Hello, my name's Daniel Thailand. I'm from the Center for Human Rights and Environment in Argentina. And I'm very happy that you've had this session here. I think it's a very important discussion. And I'd like just to raise a couple of points and hopefully get some feedback. The first point, we have presented several complaints to export credit agencies and to banks, including complaints and as networks as well. We're a member of BankTrack and of OECD Watch. 2 of those complaints were about violations to the Equator Principles, which, by the way, don't have conflict resolution mechanisms. We invented one anyway. In fact, the complaints ended up with, in 2 cases, complete withdrawal of financing from the investments. But it really goes to show how important these complaint mechanisms are. And I think that in the evolution of the banking sector and of a network like the Equator Principles of banks and even of export credit agencies, the importance of streamlining policy. To some extent that has been done with the Equator Principles because they do mirror the IFC policies, but the big failure is in not having the complaint mechanisms to file complaints. And I think this is a responsibility of the banks and of states to get their act together and do have some sort of standardized complaint resolution mechanism, whether it's by bank or a single one for all groups. And that would involve also the harmonization of policy. And I think that however fantastic it is that you are here, none of the export credit agencies that are in the panel have complete environmental policies or ones that are up to par to what is really needed in a lot of the places that we're acting. And the last point, simply, on confidentiality. Very overrated in the banking sector. Confidentiality is about not revealing business secrets. But when we're talking about human rights, when we're talking about due diligence and compliance with environmental norms, there really isn't anything. This has nothing to do with confidentiality. And so I really don't understand how the banks, and this has happened to us on several occasions, hide behind confidentiality criteria to not reveal how they're going about due diligence on human rights. Pretty basic information that we should be getting because it is a duty to protect in the case of the ECAs, but certainly not something that should be hidden behind by the private banks. Thank you.
Thanks very much, Danny. I take it you're from civil society, not business. Just for the sake of making it fair and open. So can I have the next question come from either state or business, please? State, business? So which one are you?
Well, pillar 1, it mixes state and business.
Yes, I know. All right, thanks.
Actually, I'm in the category other at the registration. So my name is Luisa Balbi. I'm from the European Bank for Reconstruction and Development, which is not an EU institution, unlike our colleagues in the panel. And our mandate is to promote a transition towards market economies in the countries where we operate. I would like to touch upon what my colleague from the EIB said. So shall we just finance in projects that are human rights perfect? And then I would like to ask something to our colleague from Conectas. Shall we just invest in countries that are democratic countries? The answer is not. And for this reason, development bank like the EBRD exist. Because basically we have to promote transition, both economic transition, and we also have a political mandate, so we believe that this economic transition will lead to a democratic transition. Obviously, as a consequence of that, as you said, we are criticized by external stakeholders with the fact, or you are legitimizing a dictatorship. But what shall we do? Shall we just pull out from the countries and just invest in Norway, I don't know, in Scandinavian countries and so on? So, and our answer to that is basically the leverage or responsibility. I don't know, let me apologize if I'm using it in a different way. So we need to stay engaged, because otherwise, how can we gain the leverage? And how can we engage in a constructive, positive policy dialogue with the so-called authoritarian regime? So there is a kind of a little bit of a moral dilemma for you, if you could address it. Thank you.
Take another question from a state, if there is a state. Are you a state? You promise?
Yes.
All right, thank you.
Thank you. I'm Hans-Petter Grabe from the Norwegian NCP. I have a question to Eleni Kyrou from the European Investment Bank on the relationship between the state duty to protect and the EU institutions. Because you said you based your work on the EU Charter, and the EU Charter, of course, is not as such an international human rights instrument. And in some cases, there might arise tensions between the Charter and the international human rights instruments. For example, recently, the Committee on European Social Rights of the Council of Europe criticized the balancing between free movement of services against the right of association and collective bargaining. And what would your position be when there are such conflicts between the EU Charter and international human rights?
The approach we've done, I mean, it's a very valid question. I don't know how to answer because I'm not a lawyer myself. What we have done is that we've decided we were bound to take the Charter into account. Obviously, the Charter is not known outside, you know, it's hardly known in the non-EU environment that we work. So, of course, the next step would be to interrogate the Charter through the International Bill of Human Rights and look at all conventions and international human rights treaties that have been ratified in the country where we're investing. So that would give us the first layer of human rights intelligence, if you wish, of how we're going to position ourselves on a proposed project, on a proposed investment in that given country. The way we've engaged with the Charter is not that we, on every project investment, we make a reference to the Charter and say, all right, what does the Charter say? Oh, we don't do that. We've integrated Charter provisions within our standard due diligence framework, and in that sense, we made a conscious choice of not opting for a standalone human rights due diligence, but to turn to enhance our existing due diligence framework and make it more human rights sensitive and responsive. So essentially end up working with a more robust but human rights aware due diligence framework. So in that sense, the contradictions that you're raising, I cannot imagine. In all truth, our revised standards were only disclosed 2 days ago, and they will take effect from 1st of January. So if in a year from now I'll have more experience of these tensions that you're mentioning, I'll be in a better place to answer, but I'm noting it for our legal counsels. As for just a quick point on something that I didn't manage, because there's a whole, there's a lot to be said about how the UNGPs influenced and informed our work. And just to put it out there in case people want to engage with that, at some point it was suggested to us that as an investment bank, our duty arises under all three pillars. And I think that generated a lot of discussion within the EIB. And in the end, we concluded that we're under Pillar 1. Our duties are firmly under Pillar 1 and under Pillar 3, but not 2. Thank you.
Thank you. Well, and now I will speak in English. I think the point is that there's many things between yes and no. It's not that you do or you do not finance projects in those kind of regimes. There are many things in between, and you have to have a step-by-step to reevaluate all the time what is the impact of the project. And there's a great publication by the Danish Institute talking about that. What are the steps, and when the yellow lights turn on and when the red light has to turn off. But yes, certain activities development banks shouldn't be supporting. Activities related to gross human rights violations, I don't know, developing the arms sector, for sure that those kind of activities shouldn't be supported. So it's not yes or not in general, but for some kind of activities there's a clear no. For the other activities, there are many things that can be done in this in-between. First of all, make it public. So if you are going to support any activity, not the ones related to gross human rights violations, but other activities, make it public before. Create a process to have input from civil society. Many times in those countries you don't have civil society because if it's an authoritarian regime it is quite restricted, but you might have input from organizations abroad. So create a process to listen what the world is saying about this regime. Have a contradictory process. So the bank has an evaluation, have a place in which the evaluation of the bank is discussed with civil society. Have concrete goals. So, okay, we were in this position, but now we want to get better. Is getting better or not? And for sure, it can happen at a certain moment you decide to suspend the project. So it's not that you get in a country and you stay. If things are not getting better, you should leave, because if not, you are legitimizing the regime. Thank you.
I'd just like to respond to the gentleman the question about the grievance mechanism. You're correct in saying that the OECD does not have a specific grievance mechanism for export credit transactions. It has the national contact points in general, so you can raise complaints to them if it is a Norwegian exporter or a Norwegian export credit agency involved, but it does not have one specifically for export credit agencies. And I can't speak for what other export credit agencies do, but at least we require grievance mechanisms on a project level by the project developer. That's one thing. The second thing is that there's a reason why we make public information about medium and high-risk projects at least 30 days before granting support. And that is, in fact, to get feedback from stakeholders, from project-affected persons. We do not have a formalized grievance mechanism around that yet. We are working on that. But in general, that is the reason why this information is made public. And to Andrea's question about the discrepancy between local standards and IFC performance standards, we have to keep in mind that the IFC performance standards are designed to deal with private sector projects. The World Bank safeguard policies deal with public sector projects. And in the OECD context, for the most part, if it's a private sector project, it's the IFC performance standards. If it's a public sector project, some can use the World Bank safeguard policies and some use the IFC performance standards. We've chosen to use the IFC performance standards because we see that there are gaps in the World Bank safeguard policies. These are under review right now, and human rights are one of the issues that they're going to address. But for us, it's difficult to use the World Bank safeguard policies because we do not see them having that coverage on human rights as the IFC performance standards do.
Of course, all of our criteria, specifically in case of BNDES on due diligence on human rights and environmental, all the criteria, it's very open and transparent. But obviously, commercially sensitive information cannot be disclosed. That's obvious. But of course, it doesn't mean that it's in a black box in the bank. It's subject to supervision by state organizations, by the central bank, by parliament, by the National Accounts Court. So a number of government organizations, they have access to all the project evaluation, but commercially sensitive information, cannot be open to the public because that has an impact on companies and on markets. But again, this is subject to supervision by specialized government bodies. In terms of, I fully agree with the comments by the colleague from the EIB and the EBRD about using the leverage of development banks. In our case, and translate this comment into a national level. So some of the projects we are engaged with, they are not perfect. They have some impacts on the environment, on the communities, and hence my anecdote about that project. And I don't know why, Andrea, that I disagree with your comments. That's a kind of proactivity it's part of our policies and has been quite successful. We have a good track record of projects that initially were assessed as having some kind of risk that we managed to structure and encourage the project sponsors to mitigate this risk, working alongside the state. Of course, the development bank is not meant to solve all of the problems. We work alongside the project sponsors, the government organizations, the municipalities or state governments, with the aim of addressing those risks when they can be mitigated.
It wasn't a criticism. In your description, you had said that you worked with the project sponsor to build houses and schools. And my question was, did you engage the government, recognizing their state duty to protect, which is what you just said?
No, of course, yes. No, thank you for your comment. Of course, so give you some more background. That's a very poor region in Brazil I was talking about. So this project came as an excellent development, generate jobs for the whole community, and not just for the whole community. They had to import people from other communities, and therefore the possible risk that the social infrastructure would not cope. But the municipality was totally engaged with this project. So they welcomed the investment by the project sponsor, by the private sector in building a new school and a new hospital, and they took over, and they, of course, they are now run by the municipality. So the answer is yes. It was a collective effort by the development bank, the project sponsor, which is a private sector company, and the municipality.
I'll throw the cat amongst the pigeons and say the community and those communities affected by the project, because I think that's also a question that was coming out of some of the discussion around that type of remedial activity. But we have a question over there, and if you could say your name and if you're from which of the stakeholders you represent, I'd be grateful.
David Allen, can you hear me? David Allen from Spectrum in Myanmar. I've been based in Myanmar for the last 8 years, and coming to the question of, do you only finance perfect projects or lend added value, leaving behind valuable precedents? So a short comment, only 2 weeks ago was involved in doing some training and engagement with groups talking on the topic of peace and human rights, and not one of 30 people in the room could quote any positive example of engagement with business. So this, if you put that in the context of this year, I think 85% of the country's oil and gas blocks are up for tender, and they're out for tender process at present. And one of the difficulties that you have is that companies coming into Myanmar seem to regard it, seem to underestimate the difficulties. So there's a certain type of rose-tinted glasses that it's possible for people to put on that make them think that their procedures are going to be able to overcome 60 years of difficulties in the country. So there's a perception that rule of law has come to Myanmar with the flick of a switch, and this is simply not the case. John Ruggie said in August 2012, heightened due diligence is going to be required in Myanmar. I guess I'd be interested in anybody in the panel who would like to comment on, in that sort of context, what do you think heightened due diligence is going to require, and how can the systems you're talking about cover this?
If I may, off the back of that question, add another question, which is, to what extent are investors and financiers increasingly being looked on to play a regulatory role. Is that fair? Is it feasible? And what does it speak for the entire sector? We have another question over there. If you could, so the lady to the left and then the lady to the right. But if I could also just ask you to introduce yourself and indicate which sector you represent.
Hello, my name is Maartje van Putten. I'm a member of the Dutch NCP. And besides that, I'm a senior advisor to the European Investment Bank complaints mechanism. So after listening to the good story, good explanation of what the EIB is, it's often a bank forgotten. Even in Europe, while at the same time it's a bank that has a budget 3.5 times more than the World Bank, also often not known. But anyway, I think you should add to it as well that we have the prideness of having also a complaints mechanism, and thus also the EBRD. So there was the gentleman of the Argentina saying the financial sector doesn't have those complaints mechanisms. Well, the multilaterals do have it. And what's more, the new one is coming now under the first Equator Bank, FMO, the Dutch Development Bank, is starting on the 1st of January. It's also its complaints mechanisms in the format of the EIB. It's quite far. Adding to the EIB as well is if people are not satisfied with the outcome of the complaints mechanism of the EIB, they can go to the European Ombudsman, who then reports directly to the Parliament. So the Parliament is on top of this. That means that they are absolutely aware it's public money. And I'm just curious if this could be something also for the other development banks, why they don't have yet those mechanisms, especially since it's public money. So that's more, let's say, my question and my addition to what was told by the panel.
May I have a question from civil society in order for the fairness? I don't know, ma'am, if you are civil society? Yeah?
Civil society. Me? A question from civil society. My name is Judith Marshall. I'm a member of an extractive sector working group at York University in Canada and have just recently retired from the Steelworkers Union in Canada. My last years in the Global Affairs Department of the Steelworkers included active membership in the international network of people affected by Vale, the Brazilian mining giant. I think what we've experienced with this company is many instances of negative impact. I could start with my own country when Vale bought 4 already established nickel properties there. We found ourselves up against a full-scale onslaught against long-established collective bargaining practices and culture in Canada. Certainly, looking at what this company does in a country where we have active partnerships, Mozambique, new coal mines there, hard to know where to start, whether it's the kind of impediments to collective bargaining there, the buying off of local people, the resettlement schemes where neither the Mozambique government nor Vale has dealt properly with rural people who were made landless and without livelihoods because of the mine. These are all old stories. I know that Vale is a major client of BNDES over the years. I'd be curious to know whether there was any leverage exercised over some of these things in recent years. But all of them kind of pale in comparison with what transpired last March when a longtime employee in Vale's Department of Intelligence and Corporate Security went public as a whistleblower and handed over more than 1,000 pages of documents to the public prosecutor in Brazil that outlined Vale's practices. So exactly the people in Brazil who have most tried to deal with those negative impacts, civil society people, social movements, fighting for rights of indigenous people in Brazil, people in former slave communities in Brazil, exactly those people were targeted, organizations infiltrated, phones tapped, inappropriate relationships with former state security officials that seemingly brought their tradecraft with them as they operated. So these are pretty shocking. And I'm again curious, what does BNDES, with the principles it holds about how it funds projects and what kind of clients it's prepared to work with, what kind of leverage is it able to bring to bear in the face of these long-standing situations and now this more dramatic situation as these public allegations against the company are widely known. Thank you.
Thank you. Thank you very much. Perhaps BNDES and then Juana can equally respond. I do understand Vale is in the audience. If they would like to respond, they'd be more than welcome to. But I'll hand over first to BNDES.
Well, first about the complaints mechanism. What we have in place, we have an ombudsman office in BNDES. So society have direct access to the ombudsman that reports to the board. So direct access to the board, so that has been. It's a fairly recent initiative in BNDES. It's developing. The office is now well equipped, and I think there's room for improvement. But we have made a lot of progress on that front. And besides that, I mentioned we are supervised by a number of government organizations that society also access directly for any kind of complaints against BNDES. In terms of Vale, I cannot comment much on the business practice. I'm not, I don't know the details about the documents that you mentioned, and we are not financing this project in Mozambique. So that's a subject I cannot make any further comments.
And before I hand over to Juana, I think that maybe there should be some discussion about the extent to which there should or could be greater knowledge and the challenges that might impede that. But Juana.
Okay. Ahora voy a hablar en español.
This was exactly the fourth point that was in my presentation, which was about grievance mechanisms. And it is not surprising what I'm about to say, because I did show my presentation to Jaime before. The principles speak about grievance mechanisms, and these mechanisms are applicable to national banks. The ombudsman of the BNDES could be used as grievance mechanisms for victims or in projects that are financed by the bank. And this has existed since 2003. This has been in place for 10 years. So it would be necessary that this be brought up to date with the principles, so that the grievance mechanisms are made clearer, because at the moment there is a website, people know that they can do something, but they don't know exactly what they can do. They don't know exactly what the purpose is. So I think it would be necessary to clarify what the process is, who can make a complaint, what kind of response is going to be given, and the ombudsman could also be very much more proactive in implementing changes within the bank, because it is through the ombudsman that that complaints are received. All of this, of course, would be an additional mechanism to the other mechanisms, the other legislative, legal mechanisms. We have grievance mechanisms which allow the bank to know which problems might arise, and this is an early warning system. Therefore, we need to try and ensure that these mechanisms work better and do respect the main principles, as well as ensure that there is greater accessibility, that they are clearer, that they are more legitimate, and they are more transparent. Because at the moment we do not know who is the ombudsman, how long they are in that function, where they have come from, and we don't know about the language as well in which they will be communicating. For example, if we have the bank's office in Johannesburg communicating in English, and then we have another person of the ombudsman speaking another language. Thank you.
Thanks. I'm going to hand over to Vale, but I'd also, in addition to asking them to respond, I'd like to ask them to speak about the extent to which protection is provided to people who make complaints to the complaint mechanisms, because this is a serious issue as well, and also the extent to which this knowledge between the financier and the corporation, to the extent to which that knowledge and sharing information should be perhaps made more robust. But I hand over to Vale.
Hi, this is Liesl Filgueiras. I am the General Manager of Human Rights, Indigenous Communities Relations at Vale on corporate level. First of all, we have responded to these accusations. They are not new. They have been out from last year, the beginning of this year, and they are also exposed in the Human Rights Resource Center. So who wants to read about this, they can have access to this there in our position. These claims were made by an employee that was fired by Vale due to the use of the incorrect use of the credit card, the corporate credit card of Vale, and that was, we have an expression in Portuguese that I don't know how to translate in English, is justa causa, just cause. Is that the way it's said in English? So it was, and he responded to that with these accusations. We did an internal auditing, and this was taken to the judicial courts, and it's been answered there, and they didn't find enough evidence, or actually the evidence presented, all these 1,000 pages, weren't, they weren't seen fit to base the allegations or anything like that. So we were acquitted from these allegations. But we are open to discuss this further and to go into more detail into this unfortunate situation. Related to Mozambique, that was also mentioned, it was an extremely positive. In the other session I participated, we had a relocation. It was an extremely challenging process because it involved a significant amount of people, of families in a region that is already vulnerable. So yes, it was a very challenging process, and we had a Human Rights Watch report on that, an investigation on that. We engaged with them, and we were, it was a very positive process we had with them, and we were able to incorporate their recommendations into action plans, and actually during the whole process we were able to already made substantial changes in our action plans and into the procedures we had, and that was recognized, and also it was a very positive process because it also divided the responsibilities among the government, the companies involved. It wasn't just focused on Vale, it was focused on the other companies that were doing resettlement procedures in the region of Tete in Mozambique. So it was extremely positive. The other thing you wanted me to comment was the relationship between financiers and was that? I'm not sure if I got the comment. The relationship with BNDES and is that?
Yeah, given that the subject of this panel is around the role of state-owned financial institutions and their multiple partners there, what is your sense around the extent to which the people who are providing the finances ought to know about these issues, can have knowledge that can mitigate, and so on?
I think there is a lot of leverage from financing institutions. We've had a meeting with BNDES.
Microphone, please, for the speaker. Microphone.
Is it on? Yeah. That provides to us, we also have part of it, a social subcredit amount that is focused on social investments, and through that we can also provide social infrastructure in these regions, especially in remote areas and indigenous communities and things like that. Just to give an example, we are going to build health health units in 6, 7 tribes in the north of Brazil, which is a role of the government, but since the vulnerability and the lack of the presence of this, it's something we were able to agree with BNDES and focused on our social subcredit. This was discussed with them, and it was provided. It was one of the examples. Part of the example he mentioned. I think all the impact management is discussed, and Vale has been evolving a lot in the terms of having a human rights policy, adopting the UN guiding principles, having risk analysis, impact assessments, all the tools in terms of due diligence on human rights, and also having a very robust community relations team on site and grievance mechanisms. So we have been restructuring ourselves since 2009 based on the framework.
But nobody really is, the local national mechanisms weren't able to assist with finding a resolution to that. The financier perhaps didn't have that knowledge, and perhaps there's a conversation that can happen here to ensure that the circumstances described by one of the participants in Brazil can in some way be ameliorated and not simply left to lie. So I'd open up that challenge to the 3 entities sitting in this room. Can I take a range of questions? So, Madam over here, and please, if you can identify your name and which sector you're from.
Yeah, thank you. My name is Heike Drillisch. I'm a civil society. I'm with Countercurrent, member of the ECA Watch network and of the German Belo network. And I have questions to 2 of the panelists. First to Mr. Zabielski, because I'm very pleased to hear that Norway is going further than the common approaches for export credit agencies demand. Because they, as you said yourself, they deplorably don't stipulate human rights impact assessments by ECAs. I still have 2 questions. And one thing is, in how far do you assess labor rights, and also within existing facilities, even when there's no great enlargement? And the other question is, can civil society get access to the human rights impact assessments that are being done? Because also in the session before, we heard how important it is that human rights impact assessments are transparent and open. The other question is to Mr. Gorstejn. And yeah, it's great to hear about your policies, but at the same time, I wonder how do they relate to your lending practice? And the Belo Dam was mentioned before. There have been huge protests against the project for many years, so you must have been aware that there are lots of problems. People are suffering because they're losing their livelihood and don't get compensation. The Supreme Court stated that the project is violating the Brazilian constitution because the rights of the indigenous population wasn't respected in the project planning. The state prosecutor of the state of Pará filed, I don't know, more than 2 dozens of court cases against the project, but still you're disbursing the loan, and I just wonder how come you don't use the leverage which you have as the main sponsor of the project to achieve an immediate stop of the project until all those problems are resolved.
If I could get a question, one from business, one from states. Sorry to be so delineated. Or none. Yes. If you could please state your name and your context.
My name is José Roberto de Andrade Filho. I'm from the Permanent Mission of Brazil. Actually, I could present a lot of questions, but I just have a comment. First, our country is extremely open, totally open, and improving constantly in institutional terms to have better channels of communication with society, in civil society, internally and externally. We are fully committed to human rights, and I think it's extremely positive that we can be here with BNDES, with Vale, with people who think differently from our institutions to know about their opinions and have a dialogue. Let me remind also that in the case of the whistleblower, as Vali has pointed out, without considering him entering into the merit of the judgment by the justice, we welcome all accusations or ideas in order to be verified. Our whistleblowers don't have to leave the country to speak about that. And we participate in the Human Rights Council. We have a human rights ministry and our parliament. So I think we can continue to improve and not restrict the discussion only to what's happening without forgetting what's happening in one country or one company, but also look at the broader causes that perhaps lie in the industry, in international trade, and in other arenas. Thank you.
Thank you. So I'll take that as an offer for you to also join the dialogue between the three entities around what has happened and what could be done collectively to solve that problem. One more question before we hand over to the panel. Yes.
Microphone, please.
Thank you very much. I'm Bird, CSO. I'm social business, in fact, but I'm registered in ECOSOC in New York as a CSO. I have so many questions to ask, but like the gentleman, I will restrict my list. So, so first question would be the rating of these agencies for the Brazilian Development Bank. The rating of the banks, how it works. And the second question, and the last one, would be the leverage of the credit organization. The leverage in percentage. How much is the leverage of the credit organization? This is Norway, is it? Norway organization. That's right. Yeah. And I will stop there. Yeah. Thank you.
Well, thank you very much. I'll hand back over to the panel. Andy, I think you're forfeiting. I think it's more interesting. Okay. Is there anything that you would like to add?
Several points. Just as bullet, from our experience, the political accountability that's inherent in our complaints mechanism, what was described earlier, that we have our own complaints mechanism and then people can resort to the European Ombudsman. This is extremely important, and I just want to make the point because it's also important for us, if you wish, for the leverage around these issues to be created within the banks, because whether we like it or not, we're not monolithic institutions. What I'm trying to say is that the bank is not one animal that thinks in one way and acts in the same way. It's made up of several parts and you have champions within, and so all I'm saying is that having political accountability at the institutional grievance mechanism level, it's extremely important. At the same time, I cannot stress enough the importance of non-judicial grievance procedures and processes at the level of each project. This is something that we continuously stress to the clients. It's an instrument that can serve in a multitude of ways, and not just for the purposes of efficiency, but also for the purposes of ownership and citizen engagement and a more democratic processes at the level of the project. It's extremely important. So that's one point I wanted to make. The second one, actually several points. So to the question on heightened due diligence on Myanmar, I can only speculate because in our case, in the case of the EIB, we haven't had the directive of, you can engage in this country yet. So it's not something that we have contemplated for real. But what I would expect, and that's why I would be drawing on UNGPs, is I would be drawing on a human rights mitigation hierarchy. I would be trying to understand much better the context in which the investment is going to take place, and think both of think of risks, think of impact, but also try to factor in the whole the sensitivity that years of authoritarian regime and ongoing conflict, as we know, in terms of religious minorities on the one part of the country is causing. So I would be trying to factor these things in. And just a comment on our duty of care in cases. I'm sorry, I'm taking more time.
Please.
Just a few words on our duty of care in cases where civil society, or we learn from the ground of the instances that were mentioned in the project of Vale in Mozambique. I think it's important for that communication to be there. We don't know everything. I would invite our civil society colleagues. We're all in a partnership, and I'm looking to you to learn. I think we're a learning community, so it's important that that information comes through, and once it comes through, that we have a duty of care to actually do our due diligence on verifying that information.
I'm sorry to rush you, but we have the tremendous services of the interpreters up until 1:15. And if I may ask for the indulgence and the patience of the interpreters for another few minutes, I'd be most grateful if that's all right, but we won't take up much of your time at all. And so I'm going to ask the panelists if they have one very small last point to make, and also if we can just bear in mind the global nature of this discussion and not just about one or two projects or one or two countries, I'd be grateful.
Okay, I'm very happy we had this conversation. I think most of the issues that worry us appeared, and also we had concrete experiences on how to improve. Just clarification, I think transparency was not overrated. He said confidentiality is overrated in the financial area or industry, so it's a different stress. I think something that appeared here and wasn't in the programming of the forum is the thing of companies spying NGOs and spying strategies. I think we could have that in the program next year. And for me, it's not clear exactly what happened in that case. I think the answer about what is the main topic of the denounce, that is a system in a company to know what NGOs are doing. The denounce is very concrete, and I haven't understood the answer very properly. Too small. I think the example of what we were doing, that is the fact of having the bank discussing with the company without external input, it was in a very clear example. The discussion happens only between the institution and the company, and you don't have the opportunity to have a contradiction, to contradict the arguments. I hope NGOs from Africa will make concrete demands to the bank once the bank is growing there, and I hope we will see changes in the next year. Thank you.
One very brief point from our, please.
To answer your question about leverage, I think that's the whole point, is that we can't put a percentage on it or some kind of numerical value. We have to look at leverage and from a dynamic perspective. With respect to Burma, I think that this is an example where the IFC performance standards footnote in performance standard 1 regarding human rights impact assessments might be triggered. So special human rights impact assessments. And finally, for export ECA watch, yes, labor rights is a focus for us. It has been for a long time, including in existing operations. And if you want to see any of the impact assessments, you go on our website. You'll find everything for Category A projects, and now we'll also do for Category B.
Thanks. Jaime, very quick.
Yeah, briefly about Belo Monte. That's a project that has been assessed by the Brazilian Environmental Agency, which is very respected and follows a very strict environmental legislation. The project has been cleared by the agency. We are financing it subject to a number of conditions, and we are financing also the project sponsors so that they fulfill the conditions, the mitigating the risk. So that's the project is moving forward, and we are confident that the mitigating conditions will be fulfilled.
A heartfelt thank you to an extraordinary panel and a wonderful audience, and thank you very much to our translators. Thanks.
You're welcome. Thank you.